Okay, so hopefully you're looking at some media law ethics slides. Welcome to the session. Um, just start off with a quick introduction to myself. My name's David Banks, and I go by the title of media consultant. But my background is journalism, and I've been a journalist now for 36 years, which is an awfully long time. So I've done loads and loads of different jobs in journalism and reporting and production of newspapers, working on websites and things like this over the years. I've been training people in media law now for about 24, 25 years. It was meant to be a 6 month secondment, but it became the rest of my career. But I still cling by my fingertips to the idea I'm a journalist. I still do write for various publications, Mirror, Guardian, do a lot of work with the New Statesman, and I do bits and pieces with BBC and Sky as a talking head, commentating on various things that go on, usually when someone's got into trouble and they need me to explain just how much trouble they're in. And I do a lot of work with students' unions and guilds across the country, especially at this time of year when the new academic year is starting. Falmouth is one of the unions that I work with, and Falmouth is also one of the unions that's retained my services for you. So today's session is really just the start of things, and today's session is aimed at really giving you an idea of some of the things to look out for when you're producing content, be it for broadcast on the radio, in magazines, online, social media, or in print. Now, however it is that you're getting stuff out to audiences, it's just to give you an idea of some of the things to watch out for. So I'm not trying to make you a legal expert today, but hopefully you'll understand when to ask a question about things, and I'm always there to support you. So if you think about, if you're producing some content and you think this sounds like something David talked about on that session, then you can contact me, and I'll give you all my contact details at the end. You can get in touch with me and you can say, look, I'm a bit worried about this. Do you think it's a problem? Should we do anything about it? How can we make it safe? And I'll discuss with you, what the risks might be. I might tell you that there's no risk at all. A lot of the time I do. But I might say, okay, that word there or that phrase or that image might be a problem. And we can discuss how to make it safe so that you can publish it, broadcast it without any sort of legal concerns. So do please use that resource through the year. If there's something you're concerned about, no matter how small it might be, just drop me a line and I'll do my best to help out with anything that is worrying you. So what we'll talk about today, I'll talk a little bit about the kind of digital landscape we work in now. And some of the issues that are very much new and potential hazards that we sort of face. And then the legal issues I'm going to talk about are libel, contempt of court, sexual offence anonymity. Now, in that segment there, I won't be talking in any sort of detail about cases or crimes or anything like that. There's nothing sensitive or distressing in that element there. It's a very short section, about 3 or 4 slides, and it purely focuses on the anonymity given to someone who makes a report of a sexual offence and how we in media have to respect that anonymity. But if you prefer to mute out of that section, that's absolutely up to you. It's literally less than 5 minutes long, so you can just cut out that section and rejoin us for privacy. Then I'll talk about privacy, copyright, and ethics. And as I said, please fire away with questions as we're going along. But afterwards, if there's a question you'd prefer to ask me after, or something that just occurs to you later on, because I provide the ongoing support, you can always drop me an email and say, I'd like to have asked this, or whatever it is that comes up. You can always ask me a question afterwards. Like I said, I give you all my contact details, including my email address. And if there's something that occurs to you afterwards, then you can just drop me an email, and I'll do my best to answer it as quickly as I can. So, first of all, what are we doing here? Why should student media worry about the law? Surely this is only something that the Guardian and the Sun and the Times and BBC worry about. And certainly when I was a student journalist a long, long time ago, that was very true. We didn't worry about media law. We didn't have a media law session or anything like this. We didn't really think about it when we were producing content, the magazine in Liverpool when I was a student that we were producing. We just cracked on and out it went, and we didn't really worry about the law. But that was because then, we were producing printed magazine, online. It might have been invented back then, but it was certainly not the kind of World Wide Web that we have come to know and love. And so none of us were producing content online. And so our content was confined to campus. The only way you could get hold of the magazine I was writing was by going to the various student bars around Liverpool, which is where we handed it out. So that insulated us from legal risk. And for a long time, that's been the case for student media, that your content is confined to campus, it is confined to the student community. So you didn't really need to worry about the law because it was very unlikely to come to the attention of someone who might object to it. The only group that we would really worry about over the years back then was like academics. If we wrote something nasty about them, then they might complain about it. But other than that, you could write anything you liked about politicians and sports stars and celebrities because they would just never see your content. Now, of course, that's all changed. And this is why increasingly students' unions have contacted me over the years, because they've become conscious of the legal risk that student media now pose, because your content goes online. And so it's suddenly, from being available only to students, is now suddenly available to the entire world. And the thing with putting stuff online is that it gets flagged up by automated searches by lots and lots of organizations and individuals, people with prominent reputations and brand images and things like this. It's not that they're actually physically looking at all the publications around the world. What they've just got is automated searches on. So when something gets flagged to them, it might be a reference to a brand that they have, or a name that they go by, or just an issue that's associated with them, then it gets flagged up to them. And they'll take a look at it. And if it's something they think has got a legal problem, that's when you start getting lawyers writing and things like this. And so unions have become conscious of this. And their insurers are as well. And their insurers increasingly have asked for this kind of training to go on to try to mitigate the growing legal risks there are for student media publication, because it is now available online and it's can be seen by anybody. The other kind of weird issue that's made legal problems more of a kind of issue for you is the improvement in quality of student media. Like I've been working with student media for a long time, and so I've seen that improvement in quality. But I can also compare what you're doing today with what we were doing all those years ago, and the change in the quality of magazines, printed newspapers, websites, radio stations, TV stations is vast. It's unrecognizable in terms of the quality compared to what we were doing all those years ago. So people could ignore us because we were rubbish. No one really paid any attention to us because it was just so obvious that we were mucking around. But now, I see a lot of student journalism work with loads and loads of student media organisations, and the quality of the content they're producing is far, far greater than it ever has been in the past. Now, that is obviously a great strength. It's great for those of you doing it. It's great for the audiences you've got. But it brings with it, as a consequence, an increase in legal risk because your content's got more impact. People pay more attention to it because of that increase in quality. And so that means people care more about what you publish about them and broadcast about them, especially if it's something negative. And so this increases the likelihood of some form of complaint. So this is what we're, talking about today. And it's a challenging environment now. There's lots out there to trip you up, far more than when I started work as a journalist. When I was working, very few people when I started working as a journalist, very few people when I was a student journalist, there were very few people deliberately trying to mislead you. You get PR organisations and things like this, but there weren't people out there deliberately creating stuff that they knew wasn't true. There were one or two odd characters. There was a very colourful character called Rocky Ryan, who made it his business to hoax national newspapers. It was just kind of like a hobby he had. He'd create these really elaborate hoaxes, which he would try to get into national newspapers, and he succeeded now and again. But he was like a one-off, you know, he was a kind of extraordinary character. Now there's just loads and loads of people making stuff up, which is out there and available and potentially might lead us astray. And social media is very much at the forefront of this. And social media can be an enormously useful tool to you in finding out what's going on in and around your campus, the wider region, and things like this. You've got access to loads and loads of people who are doing things you might be interested in. You know, they're at the site of situations that you're interested in, and you've got access to them. It's really easy to find them. One of the greatest challenges I always had as a journalist was finding someone at the scene of something that was going on who could tell me what was happening if I couldn't physically get there myself. You know, finding people who were in that area was incredibly hard. Now, social media delivers them to you, very often with a useful hashtag and things like this. And we saw this with the fire at the cathedral at Notre Dame. You might remember, about 5 years ago now. And this happened in the afternoon in Paris. And there were thousands of eyewitnesses on the streets of Paris showing us what they were seeing. Images like this one: flames erupting, smoke billowing, the spire collapsing, and streaming video as well of what was happening there. So you got a very, very vivid picture of exactly what was going on. So this is enormously useful to journalists trying to gauge the scale of a situation and just how serious it is and what the nature of what's happening there. 24 hours later, after a big event like this, that's when social media takes a completely different turn and becomes much less useful, because that's when people just start making stuff up as they're going along. And this guy started posting the next day, seemingly very expert in the fire and what the emergency services had done in the cathedral to rescue the priceless, iconography in the cathedral and things like this. And he started talking about what was going to happen next, how they were going to repair the cathedral. And he said, the last time the cathedral was damaged by fire in the 18th century, they repaired it using oak trees from the gardens of the palace at Versailles. And they replanted those oak trees then in the 18th century in case they were ever needed again. And then he put this post up that you see here: Versailles oaks, they're ready. And people love this. And this is the nature of social media. And social media spreads untruths that people want to believe. Because this has been a bit of good news, a little bit of hope, a bit of salvation, something positive to come out of this disaster. And so people loved it and were reposting it. Out it was going everywhere. Can any of you spot the problem with that picture? You might have to unmute yourself briefly to tell me if you can see the issue that there is with that image. Now, it is a picture from the gardens of the palace at Versailles, but what's wrong with it? Anyone tell me? As we've got a couple of representatives here from Nature publications, you should be right on this. Can you tell me what the problem is with that picture? No one's daring to guess. Well, they're not oak trees. That's an avenue of poplars. Poplars go up and down really well. Oak trees, great big spreading things. Someone's answered me in the chat. See if they were. Trees aren't oaks. Well done, Alexis. Well done. Yeah, the trees aren't oak trees. It's an avenue of poplars. But no one that day was going, oh, doesn't look like an oak tree to me. They were just reposting it, retweeting it, and it was viral. A couple of hours into this, the management of the Palace of Versailles must have glanced at their social media, and they see this viral story going around about the oak trees at the Palace of Versailles being chopped down to repair the cathedral. Not a shred of truth to it, absolutely made up. But people wanted it to be true, and that's why it spread. And this is what you're up against sometimes when you're producing content, when you're producing broadcasts and stories for your website, for your publication, that you're countering untruths that people really want to believe. And, sometimes it catches out even the most experienced journalists. This is John Sopel. John Sopel is a veteran BBC broadcaster. Really 40 years or so at the BBC. He's now left to be one of the main presenters on the News Agents podcast with Emily Maitlis, who also is ex BBC Newsnight. And John Sopel here is reposting or quote posting a post by Mark Stevens. Now, Mark Stevens is an eminent media lawyer, very well known in the field of media law. And Mark has found this picture. And this was during Storm Arwen last year, just before Christmas. It's one of the named storms that hit Britain, swept across the country, causing all sorts of devastation. And Mark has found this picture of a BMW up to its wing mirrors in floodwater with a somewhat ironic sticker in its back window, which Mark thinks is funny and John thinks is priceless. If you're working with imagery and you find imagery and you're wanting to investigate it, to find out whether it's right, to check where it's appeared and things like this, a really useful tool is a Google image search. It's one of a suite of tools that Google provide for journalists. And anyone can use them. It's a free, suite of tools. And Google image search is really useful. And you can drop an image into it. It will find every copy of that image that it can find that's been published online. So you can kind of track back an image over the numbers of times it's appeared. And if you drop this image into Google image search, it'll tell you that, yeah, it is Storm Arwen, it is the floods. But if you go back in time, or from all the times it's appeared, the original image didn't have the sticker in the window. Okay, it's been put in there later on by someone. It's been photoshopped in. And you might as well say, well, does it matter? It's a joke. It's just a funny picture. But if you are in the business of getting at the truth, and if you are in media, then you should be in the business of getting at the truth. Then posting stuff like this undermines your credibility, because your audience will ask, if you're posting this that's not true, then why should we trust anything else that you're putting up there? So it undermines credibility when you repeat things like this. And it catches out even BBC news anchors as well. This is Clive Myrie. Clive Myrie is the main anchor presenter for BBC News at 10. So the flagship BBC News programme, and Clive is the main presenter of that BBC News programme. You do get some others, but he is the presenter who's on most on the News at 10. He replaced Hugh Edwards. So face of BBC News, and he's found an image. Again, it's another weather image as well. And this is in the wake of Hurricane Beryl, which struck the Caribbean early on in the summer this year. And he's found this image of the aftermath of Hurricane Beryl, and salvage operations going on and things like this. And maybe his first words ought to have given him pause for thought. Perhaps he should have wondered quite what was going on here, because he says, looks like a painting. And it does. And why would it look like a painting? Well, I think most of you will look at that, and I think you'd spot straight away that it's an AI image, not just because of the light. AI doesn't get light right yet. It doesn't look like real life quite yet. Images like this, they do look like they've been sort of painted or created on a computer. But also there's loads of other things wrong with it. There's random cables stretching everywhere. The power lines that the tree has fallen apparently through are still up. You know, it doesn't make any sense. And so I think people your age are far more knowledgeable about the nature of this kind of content, and you're much more savvy at spotting AI imagery and knowing that it's fake, and knowing, and you wouldn't kind of repeat it in the way that Clive has here. Clive obviously has been caught out by it, and he's put it up onto his social media feed where it's been seen by thousands and thousands of people. He's got hundreds of thousands of followers. And lots of, there were a few people replying to him saying, Clive, it's a fake image. It's AI, it's fake. And he, about 4 days later, he quietly deleted it. This post has been deleted. Didn't say anything, didn't apologize, didn't say, oops, I got it wrong or anything like that. Just took it off his timeline. But like I said, it undermines your credibility. If you're fooled by a pretty poor AI image, what else are you going to be fooled by? When you're producing your journalism for the BBC, why should people trust you if you're caught out by something as obviously fake as this? And like I said, I think you all would look at that and think, yeah, that's a fake. That's a fake picture. That's an AI image. But AI is getting better, and I think a year from now, it'll be more sophisticated. It'll be harder to check and tell whether something is real or not. So when we're working in media now, there's a lot of stuff out there that's waiting to trip us up, waiting to catch us out. Sorry, just Zoom is glitching a little bit today. Okay, I'm going to be talking about 2 areas of law: criminal law, civil law. Criminal law, we're pretty familiar with, from TV dramas and things like this. Police investigate crimes. They send a file to the Crown Prosecution Service, and the Crown Prosecution Service will then decide whether they're going to prosecute someone for that crime. And cases go to the magistrates' courts for low-level stuff, and go to and go to Crown Court with a judge and jury for more serious offences. And the penalties that we see at these sorts of courts are usually things like fines, financial penalties, and prison sentences for the more serious offences. So we're pretty familiar with the criminal law. Sitting in parallel to that is the civil law. Now, the civil law regulates legal relationships between individuals. So there's no police involvement here. Nothing's arrestable or anything like that. This is one person or legal entity, like a company, taking a civil action against another. So they're suing in the civil courts. And cases might involve things like breach of copyright, breach of contract, privacy, libel, which I'll be talking about shortly. Those are the sorts of things that go to the civil courts, and the civil courts can't imprison anybody. What they give is remedies like damages, cash compensation that gets paid by one party to another party, or they can make a court order, an injunction stopping a certain type of behaviour, like a breach of copyright or a breach of privacy or something like this. Now, both of these areas of law apply to us in media when we're producing content. And so I'll be talking about both areas when I talk about the various sort of issues that I'm explaining this afternoon. The first of which is libel. Now, libel is one of your main worries. If you're publishing or broadcasting in the UK, libel is one of the main things that you should be thinking about and be aware of when you're broadcasting your programs, when you are producing your content. So firstly, some terminology, because you'll hear these words bandied about in relation to this area where people will talk about things being, they might say something is libelous, or they might say it's slanderous, or they might say it's defamatory. So we've got 3 words there. and they all seem to apply to the same sort of thing. So let's just kind of unpack that. Defamation, defamatory, is the term for the whole thing. It's the law that protects reputation. And it breaks down into two subgroups of libel and slander. Slander is a defamation by spoken word. So you're in conversation with someone and you say something to that person that damages the reputation of a third party. So you talk about someone else, not the person you're talking to, but someone else. The other way this can crop up is in a speech. So this is something that, for instance, officers of the union need to be aware of. The elected officers, if they're making a speech, you know, it might be an election speech, or it might be talking to a group of students. If they say something to that group of students that damages the reputation of, you know, a company or an individual, an academic, something like that, then that will be dealt with as a slander. Okay. Now, libel is a defamation in a permanent form. So that means it's in print, or it's broadcast, or it's online. Okay. Now, broadcasters might say, whoa, hang on a minute. But most of the time, the content we're producing is spoken word. You know, our presenters are talking, our guests are talking. So why isn't it slander that we're sued for? Which is a perfectly good question. And the answer is that it's because the law says so. The law says that if you say something defamatory and then you transmit it by something like a broadcast or a webcast, anything like that, that turns it from a slander into a libel. There isn't an awful lot of difference as a consequence. The remedies are the same. It's damages. You're going to get sued in the civil courts, things like this. So the content we mainly worry about in student media is, and the issue we worry about is libel, because we are producing in that way. We're producing in print, or we're broadcasting, or we're webcasting, or we're publishing to the internet. So libel, as I said, is a branch of defamation. Defamation is the law that protects our reputation. Everyone has a reputation in this country, and it's a valuable thing to have a good reputation. And so if someone publishes or broadcasts something that damages your reputation, and that's not justified in some way, they don't have a defence for that, then you could sue them for libel, for cash compensation for the damage to your reputation. And damages are very high. It can be up to £300,000 if it goes to court, which is why we worry about libel. It's really expensive. But if you get involved in a serious libel action, the other thing to worry about are the legal costs. And the legal costs in a libel action can easily amount to £500,000. I'll look about another one in a moment where the costs have gone up to very close to £3 million. If you lose a libel action as a publisher, then quite often the court will order you to pay the claimant's legal bill. So as well as your own legal bill, you've got the claimant's legal bill to pay, and you've got any damages to pay as well. So it's really, really expensive. This is why we worry about it. The Defamation Act 2013 is the latest bit of law here. And what this did is to try to catch up with the internet. It set a time limit, first of all, for all forms of publication. So if someone wants to sue you for libel, they've got 1 year to bring an action against you. From the first appearance of that content. So if you publish something on your website or broadcast up onto your website, that's the date at which that becomes actionable. If a couple of weeks after that you then decide, well, I'm going to do a bit of social media about this because I still think it's worth, you know, an audience looking at it, listening to it, whatever. So you do a bit of social media, and in the social media you repeat the libel that's in that original article. The claimant, that doesn't extend the deadline for the claimant. because it's still the same content that was originally published. So you don't, by repeating it in this way, you don't extend the deadline. The claimant still has to work to the first appearance of that content. Individuals, a person suing for libel has to show that what you've published or broadcast has seriously harmed their reputation. Which might sound a little bit subjective. Isn't everyone going to say that? That's not a decision they make. The court makes that. And the court applies an ordinary reader, viewer, listener. What would they think that the content did to the claimant's reputation? Companies have to show serious financial damage as a result of what you've broadcast or published. So that's quite a big change. Not just harm to reputation, they've got to show some loss of profits or something like that, which can be quite, it's not straightforward, them proving that. And there's some new defences which I'll talk about a little bit later on. So I'm just going to come out of this and pause temporarily because okay. So who's going to sue you in student media? Well, academic staff can certainly threaten action against you if you're kind of covering, rows on campus in the university and things like this, and criticisms being levelled at sort of academics by groups of students. Then that can sometimes give rise to legal threat. At one particular university I work with, I work with the student newspaper there. In one academic year, we had issues with two academic staff. One of them had been accused by students of Islamophobia through some of his lecture content, and the other was accused of anti-Semitism because of content of his lectures and also statements he was making in the media outside his lectures. And in both instances, groups of students, the Jewish Society and the Islamic Society, had launched petitions about these two academics on the Students' Union website. And so understandably, the student newspaper was wanting to cover this. It was a big issue in the student community there. But both academics were talking about libel actions. They were vaguely threatening. They weren't saying "I will sue you," but they were saying things like, "I'm reading what you're publishing very carefully. If I think you're damaging my reputation, I'm going to take an action against you," and things like this. So it was quite a kind of nerve-wracking time, for the student newspaper. I mean, the unusual situation here was the student newspaper was completely independent of the union in this particular university, so they didn't have the union support. Even now, I work with them independent of the students' union there. I just work with the newspaper. I don't work with the students' union there. And so the union was getting threatened with libel action. These two societies were getting threatened with libel action. And the student newspaper was getting threatened with libel action. Now, on the newspaper, we steered a very, very careful course to make sure we had a defence of what's called publication in the public interest. So we were neutrally reporting what was going on. We weren't taking sides. We weren't campaigning. We were simply reflecting the fact that a number of students had launched these petitions, and that it was something that the student community was really concerned about. Every time we did a piece of content, though, to satisfy the requirements of public interest, we were going to the two academics concerned, or whichever one that particular story happened to be about. We were going to them saying, "Okay, this is what we're going to be publishing. What would you like to say about it? How would you like to respond to it?" And if they did respond, we would include it within the content. Which is very important in public interest as a defence, which I'll come on to a bit later on. So we managed to avoid getting sued. but it was a tricky time. But it does happen that academics might sometimes threaten action. Companies trading on campus, they can be very aggressive. Companies have got a brand image which they defend very fiercely sometimes, and so sometimes if you're producing content which is critical of a particular company or its products or things like this, then they might threaten libel action sometimes. Officers of the union, the elected officers, they're elected on, certain promises they've made, and it's part of the democratic process for you as student media to check that, to find out, are they keeping the promises they made when they got elected? Are they doing their job properly? Things like this, and that's all fine, but there are limits to it. You still have to stay within the confines of libel. And we had one situation where a student newspaper got into difficulty because they accused an officer of lying because he'd failed to live up to an election promise. He'd promised that he was going to get a farmers market into the students' union. Well, he couldn't deliver it. In the time he had in office, he wasn't able to get this thing set up. And so the student newspaper called him a liar for this in an article. They say he'd lied when he said he'd get us a farmers market. And that's not fair. He hadn't lied. He thought he was going to be able to do it. He wasn't able to, but that doesn't make him a liar. It means he didn't keep his promise. You can say that. You can even say, he's let the student community down. That's all fine. But what you can't do is call him a liar. It's really, really dangerous to call people liars. It's cast iron libel every time. So they will sometimes threaten action. And students, past and present, very often funded by their parents, they'll sometimes threaten action against you as well. So the threat is certainly out there. Repetition ruling libel. This is a really important thing to get your head around in libel, and that's if we repeat something that has a defamatory meaning, we become responsible for it. So a claimant could sue everyone who repeats a libel. There's no general defence in libel of us saying, we're not saying this, we're just telling you what someone else said. That's not a defence. If you tell people what someone else said and in it you include a libel, then you can get sued for it. There is one exception to this in the case of public meetings, which I'll come on to a little bit later on. So if a claimant wants to bring action against you, they've got to be able to show three things: that the words or imagery that you've broadcast or published have a defamatory meaning, meaning damaging to their reputation. They have to show that they've been identified in what you've published or broadcast. And they've got to also show as well that it has actually been published or broadcast, that it's gone out there. Now, what they don't have to prove, the claimant doesn't have to prove that what you've published is untrue. There's no obligation on them to disprove what you've published or broadcast. They also don't have to show they've got a good reputation. Again, the court assumes all claimants have got a good reputation. Now, we know that's not true. We know that are kind of rogues and scoundrels all over the place. But as far as the court's concerned, everyone who turns up at a libel court arrives with a good reputation. So this helps them out. These two things are particularly helpful for libel claimants. So first thing they've got to show is libelous meaning. Does what you've published or broadcast have a meaning that is harmful to reputation? So what is libel? This is not an exhaustive list. This is just a brief list of some of the typical things which give rise to libel action. So any suggestions of criminality, fraudulent behaviour, being investigated for being a criminal, anything like this, definitely defamatory. And sticking in the word allegedly doesn't always help you in libel. It still damages someone's reputation. Accusing people of harassment, discriminatory behaviour as well. So accusing people of racism, anti-Semitism, Islamophobia, misogyny, homophobia, transphobia, any of those things, it damages reputation. So does that then mean that we can't expose racism when we see it? Anything like that? Well, no, because we are going to want to highlight those things if they happen in our community. But if we're going to do that, we need to make sure we've got a defence for what it is that we're publishing or broadcasting. Because if we don't have a defence, then the claimant's going to walk away with 10, 20, 30,000 pounds of the union's money. They'll be delighted that you've written or broadcast this piece about them. So we need to think about defences when we're tackling these kinds of issues. And what you mean isn't determined by you. You don't get to say, well, I've written it this way, or I've said it this way in a broadcast, and this is what I mean. The courts will say, well, what meaning will your readers or listeners take from what you've produced? And this was highlighted in this kind of fantastic libel action that exploded into the courts a couple of years ago. So Colleen Rooney was unhappy that stories were getting published about her in the Sun, which she thought were being leaked by close friends, and that they were getting these stories from her private Instagram account. So it's an Instagram account where it was just kind of other wives and girlfriends of footballers. So she vented about this on her social media, on her public Instagram. And this guy, random follower, said, this is what you need to do. You need to put fake stories on your Insta story and limit who can see each story to one of your suspects, and then just watch to see which story then appears in the Sun. So this is what she did. A fantastic piece of investigative work. And she came up with her conclusions. And she explained it in this Instagram. This is the Instagram post that she put out, where she explained what she'd done. And the fact that at the end, it's the last line that's the killer. It's ... like a little drum roll. Wait for it. Rebecca Vardy's account. Now, some people thought she'd been clever by saying Rebecca Vardy's account rather than Rebecca Vardy. But in reality, a judge decides what you mean, because Colleen said, her claim was, I just meant anyone who had access to the account. But the judge read it and said, well, I think that, and most people will think, that when you say Rebecca Vardy's account, you're actually meaning Rebecca. And so that was a big setback for Colleen. So it meant she had to defend her action, the action being brought against her. But she was quite successful in doing that, because it emerged that her lawyers wanted Rebecca Vardy's WhatsApp messages off her. They wanted her mobile phone because they thought she'd been talking to the Sun. But she couldn't give them the WhatsApp messages because she changed her phone, she said, and lost all her WhatsApps, which is terrible. So the Colleen's legal team said, that's okay, we'll speak to your agent. We'll have your agent's mobile phone because we think that your agent has been involved in this. And the agent said, well, I'd love to give you my phone, but I was on cross-channel ferry, and would you believe it fell into the channel. So it's best to avoid kind of defences like this if you're in the High Court, because judges see straight through them. And he did in this case, and so found for Colleen. But there is now a massive argument going on over damages, over legal costs. Because Colleen is now trying to claim her legal costs back from Rebecca, and Colleen's legal costs are 1.8 million. And Rebecca's side is saying they're excessive. That's too much money. You shouldn't have spent that much money on lawyers. So we'll see what happens with that. It's one to watch. The claimant has to show identification, that they've been adequately identified in what you've published. Now, we might have named them and pictured them, in which case then that's a given. But sometimes, and I do see this with student media, there's we get worried about legal issues, and so we say, right, we'll take the name out. It doesn't make you safe, because there might still be a detail in there which identifies the claimant. And the claimant only has to show that someone who knows them would recognise them. The other danger you've got though with this is what's called a group libel. This is where you um, libel a small identifiable group of people, all of whom can say this might refer to me, because by blurring identity, by taking the name out, you've pointed the finger at a small identifiable group of people. And so that's really dangerous. Lots of sets of costs, lots of sets of damages. So, you know, group libels are very dangerous. And publication or broadcast, the claimant has to show that it's gone out there, it's got an audience, it's been broadcast, it's been published on the web, it's gone out in print. Now, if you've only gone out on the web, and this would include any webcasting broadcasters as well. If you only got out on the web, then you can technically show how many people saw something before you took it down. And if you've taken it down quickly, then the courts will say you've minimised the harm. It's not worth suing for. But you do have to be quick in taking down the material. Okay. So the claimant's done their bit. They've shown defamatory meaning, they've shown identification, they've shown publication. The burden then moves to you to defend what you've done. But that would seem an absolute moment to take a quick pause. So take a quick 10 minutes break, and then we'll continue with defences. Okay, so to continue, claimants done their bit. They've shown that your content has defamatory meaning, that they've been identified in what's been published or broadcast by you, and that it has actually gone out there to an audience. So the question then is, can you defend what you've done? This really, you have to think about these things, the defences, before you get the libel threat. So when we're producing content, if we think there's a potential defamation in there, then we have to go through these defences thinking, right, which one of these might apply to the content I'm planning to use, the content I'm planning to publish or broadcast. And so the defences are truth, privilege defences, honest opinion, and some defences for publication of third-party content on your website or social media platform and things like this. The first of which is truth. Truth is a complete defence against a libel action. You can't be sued for libel for something that's true. And if you have got proof of truth, then it will halt a libel action very quickly. So if you've got things like photographs, audio, video, documentation, emails that prove the truth of what it is that you've published or broadcast, then that's fine, that's great. It will stop a libel action in its tracks. But the downside of truth is that you've got to prove it. You've got to be able to prove that this stuff is true. It's not for the claimant to disprove your content. You have to be able to prove it to the court. And it's not a defence to say we believed it was true. It was our view was that this was true. You have to show evidence to the court where the court will say, yes, what has been published here or what has been broadcast here is more likely to be true than not true as a result of the evidence you've given them. So you have to think about that. Well, what have we got to prove truth? Have we got, video, audio, photographs, things like this, documents? Be very careful of people as a proof of truth, particularly if you've only got one of them. If you've got one person who is your proof of truth, then that's a risky place to be. Because if they, won't confirm what it is that they've told you, then you're in a really difficult situation. So, and people have got a terrible habit of they'll talk to the media because they want to make a fuss about something, but then when a legal threat comes, they just vanish. They don't want to face up to the consequences of what they've said. So they leave you sort of carrying responsibility. So it is potentially a high risk strategy, truth. Absolute privilege. Now, this is a defence for court reporting. Now, in my experience, student media don't do a lot of court reporting. There are court cases that aren't, they don't do as much court reporting as kind of, daily newspapers and websites, things like this. But if you think about some of the things that you might be interested in, particularly in sort of nature publications, there's loads and loads of environmental litigation going on. In fact, there's a court battle going on at the moment in the High Court in London around Cornwall as well, around Dartmoor, and about the rights of access to Dartmoor and things like this, and wild camping and stuff like that. So there may well be court cases that crop up that are of interest to yourselves and to the wider student community there. Especially court cases. There might be court cases that involve students. There might be student victims of crime, and there's a court case about whoever it is that committed an offence against them, and you might be interested in that. So we do get interested in court cases now and again. Obviously, lots of bad things are said about people in court cases, especially if they're a defendant in a criminal case. But they don't get to sue you for libel for reporting that, because this is this special defence of absolute privilege, as long as your report satisfies these conditions. Firstly, that it's a fair report. Now, that just means a reasonable summing up of what went on in court. Accurate, getting the big stuff right, like the charge, things like that. That's accuracy. And contemporaneous. One of these horrible legal words that crops up now and again. And that just means around the same time the case is in court. So contemporary to the proceedings, basically. So rock solid defence never goes wrong, but it's narrow because it just protects court reporting, which might be of limited application to us in student media. What's potentially more useful to us is the defence of qualified privilege. Now, this protects loads of different sorts of types of information. Firstly, it protects governmental information. So if we're basing a report on information we've obtained from government, now that might be in governmental proceedings, like parliamentary proceedings, things like this, local government proceedings, their meetings and things like this, or it might be the information we've got from a governmental website. That is all protected information. So if our report is, if our content is based on that, then it's protected. What's very useful about this, though, is that the courts have extended this defence to cover any public meeting or press conference by anybody. So this could be a group of disgruntled students. They're having a meeting on campus to kind of air their grievances, to discuss their sort of grievances about something. You go along to that as a neutral observer. You're not taking sides, you're not campaigning or anything like that. You're just going along to see what's going on, and then you're reporting it to the wider student community. And if you do that, then you have this protection of qualified privilege. You can't be sued for libel for it. And this is one of the exceptions to that rule about repetition. Normally, if you repeat libelous remarks and things like this, you would be liable for them. But if you go along to a public meeting and let's say a student stands up and says things about a company that's trading on campus, and they say loads of things that are defamatory of that company, in that situation, because you were reporting a public meeting, you would have protection. So there would be an exception to the repetition rule in that particular circumstance if it's a public meeting. Again, there are some conditions for this defence. Your report needs to be fair and accurate, again, as before. It needs to be on a matter of public interest. Is this an issue that's of interest to the student community, or at least a part of the student community? Published without malice, weird little legal phrase that crops up now and again. Don't get too worked up about it. The only publication that's lost a libel defence on a proof of malice in living memory is the Daily Mail. So unless you're running your media operation there along the lines of the Daily Mail, which would be quite an unusual approach for a student publication, I think, then you don't need to get worked up about malice. Next bit is important though, subject to right of reply. Now, what this means is, no, okay, firstly, as a general rule, right, if you're doing kind of controversial stories where there are a number of different sort of sides and approaches and views of it, you should always go to people, just as good journalistic practice, go to everyone to get an opportunity to reply. It's often referred to as a right of reply. It's not really a right of reply, it's more like it's more accurate to call it an opportunity to reply. So as a general rule, you should go to everyone involved and say, you know, we're doing this story, these things have been said. What do you want to say about it? And they might say no comment. You know, they might not respond, but you've given them the opportunity, and that's the important thing. Now, in this defence, though, you don't have to proactively offer them a right of reply. So what you go along to the public meeting on campus, group of students make various statements. You can report them straight away. You don't legally, you don't need to give anybody an opportunity to reply at that stage. You've gone to a public meeting, you're informing the student community of what was said at the public meeting, you're covered by qualified privilege, and you don't need to give a right of reply. You can, if you want, if you've got time, you can say, I've been to this meeting, this was said, what's your response? But you don't have to. But then the next day, when your report goes on air, goes onto your website, the target of what was said contacts you, says, well, I'm not very happy about what's been said about me at that meeting. I want to have my say about it. To retain this defence, you need to give them that opportunity to reply. Now, it's not an apology, it's not a correction or anything like that. It doesn't need to be phrased in those terms. You just do it as a follow-up article, you know, follow-up piece or whatever. They've responded to the criticisms levelled at them at this meeting. Okay. So again, potentially very useful defence, works in lots of circumstances. Honest opinion. This protects things like reviewing. Now, in my experience, student media do a lot of reviewing. You know, reviewing arts, theatre, cinema, radio, TV, you know, all sorts of things, exhibitions, you know, places you go and eat and things like this, bars, clubs, these sorts of things. So student media does a lot of reviewing. And your reviewers are expressing their opinion about what they've experienced, whether it's watching a film or whether it's eating a meal, whatever. They've got the facts of what they've seen or experienced, and then they're expressing an opinion about those facts. And that's protected. And they can be as nasty as they like. You know, they don't have to be sort of even-handed or, you know, sort of balanced or anything like this. In opinion, you can be as outspoken, vitriolic, nasty as you like, as long as it's your honestly held opinion and you get your facts right. Now, that bit is really important. Your columnists, anyone expressing an opinion in your publication, on your broadcasts, they've got to get their facts right. If they get their facts wrong and they base an opinion on incorrect facts, it knocks down this defence. Okay, so make sure your opinion writers and your reviewers understand the importance of accuracy, getting facts right, that, you know, upon which they're building this opinion piece. Okay, publication in the public interest. This sounds quite simple, like a two-step test. It just asks, is the subject matter that you're broadcasting or writing about, is that a matter of public interest? And do you think this particular piece that you're writing about that area, do you think, or broadcasting, do you think that that's in the public interest to publish? Now, that's the bit that the courts would test. Why do you think it's in the public interest to publish this particular article or publish this particular program content? And what they'll ask about is things like your source of information, what you've done to verify it. Have you expressed yourself in neutral terms? Have you given the target of the story a proactive opportunity to reply? So now this is different to the qualified privilege defence that I just talked about. In public interest, you must give people an opportunity to reply. If this is what your defence is, if your defence is qualified privilege, you can wait until they come to you for a right of reply. In public interest, you need to go to them. If you think public interest is your defence, you need to go to the target and you need to say, this is what we're going to write about you. You know, and give them either a copy of the story, which what a lot of national newspapers do. They write the story, they send it to, you know, whoever it is that's going to be criticised in the story. And they'll say to them, here, this is what we're going to publish about you in 3 days' time. We're giving you this opportunity to reply to it. Please contact us to you know, give us your replies to the various points made in this article. So you need to either do that, send them the story, or if you don't want to send them the story, which again, I get some pushback from student media on this, saying, "Oh, we don't want to send the story." I don't know why, you know, because it's like I said, what a lot of national newspapers do and broadcasters. They'll show them the program and they'll say, right, this is what we're going to broadcast about you, but we want to know what you want to say about it. You know, so you need to give us your comments now. But if you don't want to do that, you can just send them a kind of précis of the story. But you need to make sure that that précis is very, very accurate about what it is you're going to say. Because if you don't fully inform them what it is you're going to say in your program or your article, then you're not giving them a proper opportunity to reply. If they don't realise the kind of the criticism that's coming their way, they don't understand the real sting of it, then that's not a proper opportunity to reply. So you need to be thorough in this. If you want to work within public interest journalism, then you need to be pretty assiduous in letting the target of your story know what it is that you are about to publish about them. I've kind of dealt with this now. Right, reply. Doing that. Okay, third-party content. So this is comments on your website by your readers, or if you don't allow that, comments on your Facebook page. The most straightforward defence is the first one, notice and takedown. There is a statute. I won't really go into the statutory defence because it isn't really, it's too difficult to operate and it's not really relevant. The most straightforward defence, which the vast majority of UK media use, is notice and takedown. So let's say one of your audience puts a comment on your Facebook page about a story, and in that comment there's a libel, right? You've got no liability for it at that stage, at the point at which they place it there. Even if you've read it and thought, blimey, that's not very good. I think that might get us into legal difficulty. You've still got no liability. But then the target of the comment contacts you and says, there's a libel on your website in your comments section, and I want it to be taken down. If you act promptly on that complaint, and I would suggest within 24 hours, if you act promptly on that complaint to take down the offending comment, you've got no liability. But you do need to act quickly. You need to respond to complaint quickly. And too often with this defence, people have been slow to respond to complaints. You know, they've received the complaint, but they've left it on the back burner. You know, and it's just attained more and more audience, and so it creates problems for them. So if you get contacted by someone with a complaint about comments placed on your website or on your Facebook page, get into them quickly. And again, it's the sort of thing I can help with. You know, if you want me to look at, you know, if someone complains about a comment that's on your website, on your Facebook, and you want me to look at it, then just send me a link or send me a screenshot of it and say, look, we've had a complaint about this, David. What do you think about it? Well, I might say it's fine. There's nothing wrong with it. They're just expressing an opinion and they're entitled to their opinion. Or I might say, that's a horrible libel. You know, take it down. And in which case you've responded promptly to complaints. You've got no liability. Okay. Okay, malicious falsehood. This is a little side issue that sits to one side of libel. It's another legal issue. Um, and this is where you say something about someone which is false and causes them damage. And an example of this would be saying someone's dead. Okay, it's not libelous to say someone's dead. It doesn't damage reputation. But if someone's not dead and you say they are, then clearly it could have a potential impact on their livelihood. Now, they can't sue for libel for something like that. Saying someone's dead isn't libelous, so they couldn't sue you for libel, but they could sue you for malicious falsehood because they can show that as a result of what you've published, it's caused them damage, i.e., some sort of financial loss, and they can show that you've done this recklessly. You've failed to check properly what the true version of events was. And the BBC kept doing this to Spike Milligan here, very much loved comedian in the sort of 70s and 80s, who the BBC reported was dead when he wasn't, and he sued them for malicious falsehood. And they did it to the guy underneath as well, another much loved comedian called Eric Sykes. And it was strange they said he was dead because they were using him for voiceover work at the time. So I think I might have a. Okay, thanks, Haley. Um, so, in a student context, I have had a malicious falsehood. It was at this particular student's city. There was a nightclub that would host a student around this time, around Freshers, every year, hosted a student night in Freshers Week called Carnage. I shudder to think what was going on there. But anyway, I'm not target market. So Carnage every year at this nightclub. But then one year, the student paper put an article in saying, hey, folks, Carnage has moved house. It's not at that club anymore. It's been moved to another club across the city. But it hadn't. It was still going on at the original club. Now, that's not a libel of anyone because they've not said anything bad about the original club or anything like this. They've simply said it's not hosting this Carnage student night. But it is a malicious falsehood because it's false, it causes financial damage, and it's been published with malice. Now, malice, again, it's cropped up this phrase malice. Malice here, in this instance, means failure to check properly. Had the student newspaper called up the club and said, we've heard that Carnage is moving, is this right? Then the club would have said no. We would have stopped it, but they didn't do that. And so it creates this problem. Now, the way to deal with the malicious falsehood, if it ever happens, is prompt, prominent correction. Undo the harm of the original falsehood. Okay. Okay, any questions on libel? Everyone happy? Okay, on then to contempt of court. The other segments of the session, by the way, are smaller than libel. Libel's a big issue, and so it's quite a large amount of slides and things like this. But the other parts of this session are smaller segments, so don't worry, we're not going to be here at 8 o'clock tonight or anything like that. Okay, contempt of court protects the judicial process, protects a person's rights for fair trial. We can interfere with that by commenting about police investigations, trials, that kind of thing, running coverage of these things. Now, it's not a ban on publication. You can publish things about crimes that have gone on and investigations that are going on and court cases that are going on. But what we mustn't publish is something that causes serious prejudice to the course of justice. So we need to think about this. There's no limit to the fine that can be imposed for contempt, so it's really expensive, tens of thousands of pounds, and they can still jail your editor, which might be quite entertaining, but definitely to be avoided. Now, the last time they jailed an editor was 1949. It was the editor of the Daily Mirror who, in the middle of a murder trial, ran a feature speculating that the defendant was a vampire. So they don't do papers like they used to. Anyway, he was sent to prison for 3 months for that. Now, they don't give editors personal fines anymore. They don't jail editors anymore but they do sometimes give them a personal fine. So as well as fining the publication, they sometimes fine the editor too. So when do we worry about contempt? We worry about contempt if there are what's called active proceedings. And this is stuff we find out from the police. So let's say you've got some crimes committed against students in the campus area, and you're covering those issues. Then what you need to do is check with the police press office. Have they arrested anybody? Have they got a warrant out for someone's arrest? And if the answer is no, contempt vanishes as a problem. You can't be in contempt where there are no active proceedings. But you must check with the police whether there are or not. But then eventually the police might say to you, yes, we've made an arrest in connection with the crimes on campus. What that means then is that contempt starts to apply. And so we mustn't publish or broadcast anything causing substantial risk of serious prejudice or serious impediment to the proceedings. That's the technical legal definition of what we mustn't do. So what does that mean? What mustn't we do? What can't we publish anymore? Well, pictures of an arrested person, if there's going to be an ID parade, and again, the police can help you with that sometimes. Previous convictions. If someone makes a first appearance in court, you Google their name, you find out they've got a load of previous convictions for offences against students. And that's really interesting, but it's very prejudicial. Juries, surprisingly, perhaps, juries don't get to know about a person's previous convictions, not allowed to be told about them. So we mustn't put them in there because they're potentially problematic. Assumptions of guilt, character assassination, this is the kind of thing that goes on in the Sun and things like this. I don't imagine you'd get into this kind of thing. Criticising the defence, that sometimes happens has happened with radio presenters in the past, where radio presenters might be talking about a court case and they run from kind of a factual account of the court case and they get into kind of opinion about it and things like this. Really dangerous to be offering opinions about live court cases. Okay. In this country, that is, if it's overseas, publish whatever you like, write whatever you like, broadcast whatever you like, it's fine. It's overseas. But contempt of court applies to cases in this country. What you're trying to do with contempt of court, what contempt of court tries to do is to prevent witnesses to stop them being interfered with so they don't give true testimony, and to prevent a jury, to stop publication preventing a jury from reaching a proper verdict. Okay, so that's what contempt is trying. Two groups of people contempt is trying to protect: witnesses and jurors, to make sure they aren't exposed to something which seriously prejudices them against the defendant. On the other hand, things you can publish, for example, if you've got a student defendant and they wanted to protest their innocence, they wanted to say, I didn't do this, I was innocent this day's long, or whatever. Or if you had a student who was on environmental protest and they were being prosecuted and they wanted to talk about why they did what they did and why they don't think they're guilty and things like this, that's fine. Because the presumption in law is that they're innocent till proven guilty. So someone protesting their innocence isn't being told something the jury aren't going to be told to assume anyway. So that would be fine. Okay. Any questions on contempt? Okay. On then to sexual offences. As I said, this section is very brief. But please, if it's something you'd rather not listen to, then that's absolutely fine. It's about four or five slides, like I said. So what we're talking about here is anonymity. Anonymity for a victim of sexual offence applies to them as soon as they report the offence. But that report doesn't have to be to the police. So there might be no police investigation going on, no court proceedings going on, but nevertheless, this person has reported this matter to someone, and that's the thing that creates anonymity for them. The conditions of anonymity are very wide-ranging. You mustn't broadcast or publish anything, any matter that would identify this person as being a victim of a sexual offence during their lifetime. So it's much more than just not publishing a person's name and address. It's anything about them which might allow someone to identify them as being a victim of a sexual offence. The thing we have to remember with campus as well is that it's this kind of semi-closed community. You know, you all socialise in a lot of the same places, you work in a lot of the same places, you study in a lot of the same places, you live in a lot of the same places, and all this conspires to make you much more identifiable to one another. You know more about one another, and that can mean that a detail that might be innocuous about someone in the wider world can be much more identifying when you apply it to a student. So you need to be very careful about these sorts of details about people in these sorts of situations. Anonymity can be lifted, and most often this happens when a victim gives their written consent to do so. So that written consent doesn't need to be a kind of lengthy legal document. It could be a one-line email or something like this, text, simply confirming that they consent to be identified. But the thing to remember is they can withdraw that at any time in the future. So if they contact you and say, you know, I don't want that article up anymore, then you need to give effect to their wishes. You know, you need to comply with their desire to re-anonymise themselves. Okay. On then to privacy and confidentiality. Now, this is a new area of law. We've only really had effective privacy rights in this country since about 1998 with the advent of the Human Rights Act. But what that act does is it says simple things like we've got right to privacy, you've got right to private to family life, you've got a right to freedom of religion, freedom of expression, things like this. It doesn't go on to define, for example, what privacy is, what it covers and what it doesn't. That's been left to the courts to develop since 1999. And the courts have said the sorts of things that are private are things like health and medical treatment. It's kind of common sense. Sexuality, gender identity, relationships, things like this, definitely private. Academic record and attendance is a private matter as well. Two things will affect this privacy, though. The public interest. Again, the public interest what the public interest here tries to do is strike a balance between rights to privacy, which all human beings have, and rights to freedom of expression, which again all human beings have. One right doesn't necessarily overwhelm the other. So the public interest tries to strike a balance between that. The court's looking at what is in the public interest, tries to strike a balance between those competing rights, freedom of expression and privacy. So we can sometimes breach a person's privacy if it's in the public interest to do so. Or they might have put it in the public domain themselves. Again, some people overshare huge amounts of information about themselves on unlocked social media accounts, and that can mean that their right to privacy over that information diminishes, because if they're sharing it to large numbers of people, the courts will say it's not private anymore, and so you know that can affect our right to publish. Crime and arrest. This has been changed significantly as a result of privacy as well. Starting with the Cliff Richard case, the BBC were tipped off that his house was going to be searched, and so they flew a helicopter over his house during the search. He sued the BBC for breach of privacy for this, and they argued public interest, that he's a national figure, national treasure, and so it was in the public interest to know what was going on with this investigation into him. Court disagreed. The court said no, he's got reasonable. People being investigated by the police have got a reasonable expectation of privacy. And then that was moved further on by a case involving a guy called Aldin Al-Sikri and the Daily Mail, where Mr. Al-Sikri was arrested in the wake of the Manchester Arena bombing. Now, he was arrested because his phone number appeared on the mobile phone of one of the bombers, but it emerged he was completely innocent, had nothing to do with the bomb plot or anything like this. But he was arrested and held for 5 days under anti-terror legislation. So he then emerged from custody to sue the Daily Mail, because the Daily Mail had found out about him, and they found out that he was a Libyan pilot. And so they'd run a piece speculating that there was a 9/11 plot going on that he was involved in. So he sued them for breach of his privacy. And again, the Mail argued public interest, that this was a massive terror incident, and it's in the public interest to know all of the different investigations that are going on. Court disagreed. They said someone who's been arrested by the police has got a reasonable expectation of privacy. So you need to think about this. If you're reporting things like arrests on campus and stuff like this, then very likely the people being arrested in those circumstances, unless it was a very public arrest, the people arrested in those circumstances have got a reasonable expectation of privacy. Letters and emails, these are private matters. Letters are interesting because if you send a letter to someone, they own the letter. Same with an email. They own the email kind of collection of electrons, but they own the email, or they own the letter. But you own the copyright of it, and you also have privacy rights over it. This was explored by the Duchess of Sussex in her action against the Mail on Sunday, because she wrote to her father pleading with him to stop talking to the media just ahead of her wedding. Pleading with him to stop talking to the media. He did what any loving father would do in those circumstances. He sold the letter to the Mail on Sunday. So she brought an action against the Mail on Sunday for publishing that letter. Now, the Mail on Sunday argued it was in the public interest. They said it's in the public interest for their readers to know the dysfunctional family that Prince Harry was marrying into, which is a bit rich given what's gone on in the royal family in recent years. But anyway, that was the Mail's argument, public interest. The court dismissed it, and Duchess of Sussex is probably about 5-0 up against the Mail on various actions that she's taken against them. Whistleblowers. Yeah, in my experience, student media do a lot of whistleblower stuff. But often it's students, and they'll come to you with stories of environmental health regulations being flouted, environmental standards being flouted, the public being ripped off, safety issues, working hours problems, things like this. Whistleblowers are, by definition, almost blowing the whistle on their employer. And so they are breaching a duty of confidentiality. And we might say, but we're not in that relationship. So if a whistleblower comes to us with information, we're not employed by their employer. The thing with confidentiality is it sticks to the information. So once you get given some information that is in breach of confidence, you become bound by the duty of breach of confidence. And so we can only then reveal that information if we can show that it would be in the public interest to do so. And so you need to have that conversation. If you're dealing with whistleblower content, you need to just sit and have the conversation. Are we satisfied that what this whistleblower is telling us is, pardon me, is a matter of public interest? Okay, any questions on privacy? Okay, on then to copyright. Now, this is an area that's costing students' unions quite a lot of money. And it's because of the easy availability, particularly of imagery online. Now, copyright is created automatically in the creation of a work. So if you see something, it might be an image, it might be a piece of text or whatever, and it doesn't have a little copyright symbol on it, that doesn't mean it's free. Copyright isn't required to be notified anywhere. It's not required to be registered anywhere, anything like that. If you take other people's stuff without their permission, then you're breaching their copyright. It lasts a long time. So for text and photography, it lasts for the creator's lifetime plus another 70 years. So material is coming out of copyright this year, 2024, for creators who died in 1953. That's how long ago they have to have died for their content to be public domain now. So the vast majority of content you see online, photography, all these sorts of things, it's not public domain. It's owned by somebody. Film copyright 50 years, Crown copyright, me and our government 125 years. But compare that to the US federal government. The US federal government is copyright free. And so it's, that's a very substantial pictorial resource. Very different attitude to our own governments, where they grasp things for 125 years. Fair dealing, you can use a limited amount of someone else's content without their permission, as long as it satisfies the tests of fair dealing. It needs to be properly accredited. You need to say to your reader, viewer, listener where that content has come from. It needs to be a reasonable extract as well. Now, what's reasonable? The courts will say they want you to leave behind value. Don't take so much from the original, you destroy its value. Okay. And this will protect your use of text, audio, video, film clips, but not still photography. You can't fair deal a still photograph. So there's a lot of technical detection of breach going on now. A lot of agencies, big archives, picture agencies, using technical means of detecting breach. And so there's one that's been used a lot called PicScout. PicScout is a bot that just searches the web looking for copies of images in its memory. And Getty Images, for instance, they use PicScout, and the average bill they send out for one unauthorized image is $5,000. And Getty are making $2 million a year just from PicScout, finding unauthorized use of that imagery. If you use Creative Commons imagery, which are a great source, great resource, stick to T's and C's on their website for use. Bylining the photographer, leaning back. Bylining the photographer, linking back to their site and things like this. So these are common T's and C's that they put in. So make sure you stick to them, because otherwise you end up paying for a photo that should be free. So I've seen some really big bills in this in terms of detection of images. The biggest one I've seen was the Radio Society, and they got a $9,000 bill for they've been taking images from the Reuters picture archive website. So they've taken large numbers of images from there over a period of 3 years, and they got this bill for £9,000, which actually, when you looked at the number of pictures they'd taken over the period they'd taken them, $9,000 was not an unreasonable bill. However, we managed to negotiate it down. And if you get contacted by these kind of claims agencies, and they go under all sorts of names, Pixie, Pick Rights, that kind of thing. If you get contacted by them, you can always negotiate them down. They might offer they might sort of send you a kind of offer letter saying you can settle this matter for £750. Well, you want to go in with a really low bid to see whether they can come down a bit. The £9,000 one we got from Reuters, we managed to get that down to less than 1,000 by negotiating with them. So it's always worth doing that. And this is an example of pursuit. It was a meme that happened a few years ago. You might possibly remember it, where a woman had gone shopping for a wedding dress, a dress to wear to a wedding. And she found this one, and she sent it to her friend for an opinion. And the friend noticed that it wasn't quite easy to tell the colour it was, depending on the light and angles of the sun and things like this. And so put it up online, asking what do people think of it. And it became a meme. Lots of people, everyone had an opinion on what it was, things like this. So it got lots and lots of circulation. And lots of newspapers jumped in on it as well. Once it had become this kind of internet phenomenon. And since then, the woman who took the picture has been signed up by a picture agency, and they've gone round all these mainstream publications around the world, sending them a bill. She's absolutely minted now. She made a fortune from this. Okay. And then finally to ethics. You're not signed up to ethical regulators. Radio station, I don't now, remind me actually. Um, are you broadcasting to the airwaves or are you webcasting there on the radio station? Can anyone unmute themselves and answer me that question? I've got a question, I've an answer in the chat. We're webcasting. Thanks, Kirsty. Yeah, I mean, that is the model that most. You've preempted my next point. Thank you very much, Kirsty. We try to abide by Ofcom rules. That's a good practice. Yeah, none of you are bound by regulators. So whether you're publishing in print, magazines, online, or webcasting for the radio station, you are not bound by a regulator. However, it's a good idea to have an eye to ethical regulation for a couple of reasons. Firstly, I can't speak for the Students' Union there, but I'm pretty sure they want an ethical media operating on campus. And that it's going to save an awful lot of confrontation if you are cognizant of the ethical codes that apply and that you're applying them to your content. It makes it a much easier way to run things. It also forestalls complaints. So if someone complains to you about your behavior, or your tackling of a certain issue and things like this, if you're able to say, well, in doing this, we have complied with all the standard media ethical codes that apply to this kind of content, then, again, that helps. The other reason is that, lots of you might have ambitions of going into media. And if you do, you want to be able to show prospective employers content that is broadly in their kind of ethical ballpark, where they think, here's someone who can operate in our newsroom, in our studios, and produce content that isn't going to get us into ethical trouble. Because if they see someone who's wildly outside their ethical frameworks, they're going to think, well, yeah, it'd be enormously exciting to work with this person, but they're going to get us into so much trouble that it's not worth taking a chance on them. So, it's beneficial to be thinking about the regulatory frameworks in which most people operate. Now, for print online, the regulator is IPSO, the Independent Press Standards Organisation. And it administers and oversees the Editor's Code of Practice. Now, the Editor's Code of Practice are the ethical rules for print and online journalists in this country. It's one side of A4. You can find it on the IPSO website, one side of A4. You can download it from there. And also on there, you'll find a thing called the code book, which gives you, it's not massive, it's about 50 pages. It gives you lots of information about how the code is applied, how individual clauses of the code are applied and what they mean, and things like this. So it's a useful publication. The broadcast regulator is Ofcom. Now, Ofcom is much, much more powerful because broadcasting is seen as a more powerful, more influential medium. The regulator here is Ofcom. Now, the Ofcom code is huge. It's so big you wouldn't want to drop it on your foot. It's massive. But you can break it down and focus on the clauses that are most applicable to your content, the content you're working on. And again, in the Ofcom code, there's a lot of information and guidance on how the various sort of codes, the various parts of the Ofcom code operate. Now, the most common ethical complaint, if you went out and asked your fellow students, you might get answers like things like intrusive behavior, and bias and things like this, which do generate, those things do generate complaints. But the most common ethical complaint by a huge amount is accuracy, just getting things wrong. Now, you are going to get things wrong. That in itself is not an ethical failing. What's important is what you do next if you get something wrong. And the codes of ethics, both for Ofcom and for print on and for IPSO and print online and broadcasting, the most common ethical complaint is accuracy. Just getting stuff wrong. So the ethics here then is what you do if you get something wrong. And what the codes say is if you make a serious error of accuracy, so this is something which materially misleads the reader or the listener or something like this. So it's not just a kind of minor misspelling or something like that. You don't have to kind of go into huge lengths to correct that. But if you commit a major inaccuracy, then what both codes expect, both the print code and the Ofcom code, what they expect is you correct with what's called due prominence. Now, due prominence is you put the correction in a place within your schedules, within your website, within your print publication. You put your correction in a place where it's going to be heard or seen, read, watched by the people who originally saw the error. So you're thinking about, in terms of print online, you're thinking about where are you putting this in the website? What page does it need to sit on? With broadcasting, webcasting, you're thinking about timings. Are the people who heard this when it went out, are they going to be listening when the correction goes out, so that you are reaching as many of the people who saw the original inaccuracy as you possibly can. Okay. And if you do that, you've satisfied the ethical codes. You've faced up to it and you've satisfied the ethical codes. Okay. So have a copy of that as a code to hand. The Ofcom code, you probably have to have it online because it is so big. The editor's code of practice, print online, one side of A4. You can download it from the IPSO website, hand out a copy to all of your content producers, and that will that will inform them of the requirements of the code. And this draws us to a close. In all of this, you're trying your absolute hardest not to be the Sunderland Echo and to commit an error in the way that they did. Because the Sunderland Echo were covering a street attack that had happened in Sunderland. And they'd had a witness appeal from Northumbria Police, standard sort of story. The police are looking for witnesses, and so they were covering that. And the police had issued an EFIT, which is a kind of electronically produced, computer-produced artist's impression of the person they want to find in connection with this crime. And so the Sunderland Echo duly published this witness appeal from Northumbria Police, along with this EFIT of the wanted man. And I think you'll agree, quite an eerie looking individual, sort of piercing gaze and quite well dressed, it has to be said, for a Sunderland street attacker. Well knotted tie, hint of a scarf around his neck. And this is quite an artistic EFIT as well. This isn't the usual standard of cobbled together kind of imagery that we get from the police. This is a cut above. And that's because the artist that produced this particular EFIT, artist's impression, is none other than Henri Matisse. And this is a picture of Sergei Prokofiev, the long dead classical composer. Now, how, you might ask, how did a picture of Sergei Prokofiev end up in the Sunderland Echo next to a witness appeal about a street attack from Northumbria Police. And no doubt the editor of the Sunderland Echo that morning was probably having a no biscuits meeting with his production staff asking this very same thing. And to understand how this happened, you need to understand how newspaper pages were put together then, and probably still are to a certain extent. A page designer will design a page just drawing boxes on a screen. They'll draw a box for the headline, a box for the text, a box for the picture, and a box for the caption. And all of these get filled in later on in the process. So the page designer will have a look at the picture and they'll decide how they want this picture to appear on page, how big they want it. But then it has to be processed by the digital picture desk to produce an image to the right size for the page. So the page designer gives the instructions to the picture desk and sends the page on down through the production processes, where sub-editors then will usually take over, and they'll do things like write the headline, sub the text, making sure, checking it for accuracy and spelling and grammar and style and things like this, getting it to the right length for the page so it fits onto the page properly. And the sub will then also place the picture on the page. The picture will have been processed and put into a digital picture basket. So the sub will then pick up the picture and drop it onto the page. And they'll write the caption for the picture. And when they drop the picture onto the page, what they're meant to be doing is looking at numbers, because there will be a number assigned to this box by the page designer. You know, his system will have given that box a number. And the number in the box will correspond to a number in the digital picture basket. So that's meant to be a foolproof way of getting the right picture into the right box. Okay. And one would think, you just look at the number, 347 on the box on the page. You look for number 347 in the digital picture basket and you pick it up and you drop it in. Simple. What could possibly go wrong? Well, what goes wrong is not understanding how people's brains work. We don't work well with numbers. We like looking at pictures. The first thing anyone looks at when you're designing pages, whether you're designing for the web, designing for magazines, designing for newspapers, the first thing any of your audience look at, the first thing they look at is the picture on the page. Even subconsciously, the first thing their eyes will always go to is a picture on the page. So people like imagery, they don't like numbers. And so the subs are no different. So they would look at the digital picture basket, and rather than doing things like look at numbers, they would look at the tiny little thumbnails in the picture basket, trying to ascertain which thumbnail was meant to be going on their page. And the sub on this page looked into the big picture basket and he saw something that looked like a sketch, that looked like something that might be an artist's impression or something like this. So he picked it up and dropped it in. And no one in the processes afterwards, no one else looked at that page and queried it. Now, I worked on crime for a long time when I was working as a reporter, and I've dealt with loads and loads and loads of kind of e-fits and artist impressions and things like this. And had I seen that page, I'd have looked at that and said, that's not an artist's impression. That's not the right picture. It's not an e-fit. Okay, something's gone wrong. But I wasn't in the process, and no one like me was in the process. So no one in the process at that Sunderland Echo was going, that's not the right picture. So out it goes, sails into the newspaper, onto the streets of Sunderland, where no doubt the next day, posses of vigilantes were scouring the streets of Sunderland for a long dead classical composer in connection with this street attack. But, you might ask, what was Prokofiev doing there in the first place? Why was a picture of Prokofiev sitting in the digital picture basket of the Sunderland Echo, waiting to be picked up by a hapless sub and dropped onto the page? Now, can any of you answer that? The only person who's been able to answer this in the past was on a session I did for GCHQ. Okay, so this is Alan Turing level, genius level trivia. Can any of you tell me What is the link between Sunderland and Sergei Prokofiev? Has anyone got an answer? You might have to have some connections to the northeast to know this, or you might need to be a football fan. Anyone? No clues? No one going to venture a guess? Okay. Right, well, GCHQ's title looks like it's remaining intact. Sunderland Football Club, when they run onto the pitch at this time, I think they've changed it since, but back then when this happened, when Sunderland Football Club ran onto the pitch at the start of a match, they would run onto a piece of music, like most teams do. Whoa! Someone's come in with a late answer. Let's see, I just need to get out of my slides to see. Correct. So, Emily, you just about got there. Can you tell me, Emily, what is the Sunderland football anthem then? No, you busily. I don't know. Just a guess. Yeah. Well, you guessed correctly. It was the Sunderland FC football anthem, um, and it was the Sunderland FC would run onto the pitch to a piece of music called "The Dance of the Knights," which is from Sergei Prokofiev's opera Romeo and Juliet. It'll be familiar to those if you watch The Apprentice. It's the dramatic orchestral music that plays at the start of The Apprentice when the helicopter's soaring over the London skyline. That's the Dance of the Knights. So that was the piece of music. That's why Prokofiev was there. Elsewhere in the newspaper that day, they were doing a feature about Sergei Prokofiev, the composer of the Sunderland FC anthem. And that's why he ended up there. Now, the point of this for all of you, though, is checking, the importance of checking, having as many people as possible looking at content, particularly content that you might be worried about. Just looking out for and just raising issues and saying, do you think we ought to send that to David? Do you think we ought to ask David about that? Because I'm here waiting, but if no one asks me, I can't give you the answer. So it's always best, even if you have the slightest concern about something, send it my way and I'll give you an answer as quickly as I possibly can. I usually answer the same day, within a couple of hours of sending a query. So I won't keep you hanging around for long waiting. Yeah, if you, no matter how much, you can send me as many queries as you want. And I'd rather you send it to me than you worry about it and things like this. So this is how you get in touch with me then. Email address, davidbanksmedialaw@gmail.com. That's the best way of getting hold of me, because you can send me the contents, you can send me a link, you can, send me text to look at, whatever. And I usually like to do it that way. I will answer if you it's a real emergency, you need to phone me, then you can always do that. But I will usually ask you to send me the content because I'm going to want to see it. And I like to be able to send you back some written guidance, so then it's clear for you, rather than you trying to phone me and then trying to remember what I've said to you. It's much better for you to have it clearly written in an email so that you can apply what any of my guidance to what it is that you're doing. Lots of times you'll send me a query and I'll say it's fine. I'll say there's no problem with it. Don't worry about it. It's absolutely fine. But I'd rather you did that than didn't send it to me and then there's a problem. Website, davidbanksmedialaw.com, bits of media law on there, what might be of use. Mobile phone number, don't phone me up if you've been arrested, okay? Duty solicitor will get you faster than I will, especially down in Falmouth. I'm in North Yorkshire, okay? You're a whole flight away before I can get to you, so duty solicitor. And if you're on the health site that is X, formerly Twitter, I'm still there despite Elon Musk's attempts to make it unusable where I'm at Debanksy. So do give us a follow if you think it would be useful. Again, I do bits and pieces of media law. I comment on stuff that's got media law connections and things like this.